Is that the motion
Speaker.
call David Clendon.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to take a third reading speech in this Aquaculture Amendment Bill. The Primary Production Committee in its report back suggested that the bill provides, and I quote, an efficient legislative and regulatory framework that would enable the sustainable development of aquaculture within the coastal marine area. And so one cannot argue with the aspiration behind that to actually develop a sustainable aquaculture industry in New Zealand. But sadly, this bill falls far short of giving us any confidence that the outcome would or could be achieved under the provisions within this bill. The debate around this has been highly coloured by this constant reference to the billion-dollar industry emerging, the claim that aquaculture is the next big thing. And I think there's been something of a lack of a reality check around that. There seems to have been very little analysis of where that number came from. It would require something like a threefold increase in the current export earnings, sitting around $370-odd million. And it's not entirely obvious where that threefold increase would come from. The market has not been waiting for New Zealand to sort out its industry. This unexamined proposition clearly has blinded a number of participants in the debate to the more sober and measured assessments and submissions that pointed out at length again and again that this model proposed will not provide the long-term solution to the underlying weaknesses in our present marine management system. The total water space currently occupied by marine farms is in the order of 5,800 hectares or thereabouts. It's estimated that the area needed to generate this hoped-for $1 billion would similarly need about a threefold increase to something like 17,000 hectares. The Minister referred to a relatively small imposition on the total marine space surrounding New Zealand, and at one level he's quite right. But that clearly overlooks the fact that the waters that will be required and sought after for this activity are waters that are also sought after for numerous other activities. There will be significant competition for a relatively small amount of water. The proposed legislative and regulatory measures to manage the allocation are very unlikely to have any chance of managing the legal, regulatory and practical challenges that the level of demand for this water will throw up, and so have little chance of achieving their stated purpose. It's clear that a very narrowly defined notion of economic efficiency has driven and is seen to be the guiding light in this debate in the proposals within the bill. And we could talk at length about the relative efficiency in ecological terms of the activity of farming, particularly of finfish farming. The proposition is that we will import large volumes of fish food, which are already depleting existing wild stocks, that will convert this to higher value fish product. At a ratio, we'll generate about 1 kilo of product for 1.8 kilos of input. Ecologically, sir, this is nonsense. Short-term economic, yes, it may make sense, but that economic return relies on us mining, effectively, ecosystems. Not our ecosystems, but in the scheme of things, we will be mining ecosystems, and that is seldom a recipe for a long-term return. There have already been numerous local challenges and to the councils and to the Environment Court, asserting that many of our more popular waters are already farmed beyond capacity. NIWA, our CRI, has already on many occasions stated we simply don't know enough about the complex processes and interactions within and between the farmed areas and the unmodified or wild environment to have any confidence about the future of this. Systematic environmental monitoring has not been undertaken. We simply do not have the robust scientific data and knowledge which would inform good management decisions. And that is not an imagined view, that is an empirical view put forward by our CRIs who are clearly disinterested in the economic sense in this. The oft-repeated message from our scientific, our ecological community is there's an absolute and urgent need for good quantitative and qualitative data to inform this truly sustainable approach. allowing the second gold rush, and inevitably that's what we'll see. In the absence of that underlying science is guaranteed to undermine efforts to establish a sustainable industry. We are told that this new legislation will normalise aquaculture to the extent that it will put it within the ambit of the RMA. It'll remove the aquaculture management areas and put it in line with other decision-making processes around resources. Now, the immediate and obvious objection to that, of course, is that the proposition that the areas in question, the space in the marine environment, is currently commons. It is public domain, public space that is otherwise available and accessible to all. And assigning exclusive use of public domain to a commercial venture, and remembering that to achieve the wished-for $1 billion bonanza, we need to alienate from public domain something to the tune of 12,000 hectares of marine space, can in no way be considered normal or desirable practice, especially given that the management and regulatory regime is inevitably going to be dominated by very few and some very well-funded and some very determined interests. Arguably, what we are seeing is in fact the new normal under this government, in the same way that this government is doing its best to eliminate opportunities for public participation, to reduce reasonable safeguards and opportunities for assessment of applications. So too are we seeing a determined push to drive open the gates to exploitation of the marine area without real thought or consideration of the longer term damage that could be done here. The bill in one particular clause in 186D makes provision for the Chief Executive of the Ministry of Fisheries, for example, says he may consult while making decisions in respect of aquaculture. It's the belief of the committee, and I quote, that proceedings without consultation would be appropriate in most cases to help speed up the process. I have never seen such a clear enabling statement that will licence future chief executives to be very, very miserly in their approach to consultation. We will see an ambivalence to consultation and likely a very hostile approach to engaging with legitimate concerns and interests around this. The chief executive is empowered but absolutely not obligated, and indeed, under the wording from the Select Committee, probably disencouraged to consult with people or organisations who he or she considers represent the classes of persons who have customary, commercial or recreational fishing interests that may be affected. In short, the executive is given considerable licence again, not only about whether or not to consult, with a preference for not, but also about with whom he or she consults. We are told that the RMA process, the application process, will be conducted in an integrated fashion with any process deemed necessary to establish the existence or otherwise of a UAE, an undue adverse effect on commercial, customary or recreational fisheries. So the mechanisms proposed here are complex, they are multi-layered, and they require the engagement and some level indeed of cooperation of numerous competing and often conflicting industries. I would confidently predict that if there is an economic bonanza in this legislation, it will be a bonanza for the lawyers. The so-called integrated approach is almost doomed, almost certain to generate highly charged and expensive litigation with appeals and counter-appeals and claims for cost and compensation. So this proposed legislation, it takes real risks with our environment. It absolutely works against ecological, sustainable best practice. It establishes very weak provisions for democratic process, and we're relying on some very highly questionable regulatory mechanisms to lead us to this hoped-for, dreamed-for billion-dollar future. All this, to use in the government's favourite phrase, balanced by the economic opportunity, so the substance of that proposed economic opportunity bears some investigation. Aquaculture is not an industry for the faint-hearted or the undercapitalised. There are very few organisations, companies within New Zealand with sufficient capital to bear the inevitable high cost and interrupted return of a very vulnerable primary production industry like aquaculture. It would be our sure forecast that in time this industry, if it goes ahead, will in fact be dominated by very few, probably overseas interests. There will be very little benefit to New Zealanders or our environment. Thank you, Mr. Speaker.
I call Hilary Calvert.